Our case involved a young woman who was a sergeant with the New York City Police Department and had been on the department for almost 16 years. She had a young daughter, and she was no longer able to work as a police officer because of the traumatic brain injury she suffered. Hi, my name is Joseph Donahue, and I'm a partner here at Block, O'Toole & Murphy. Today I'm going to be talking about a case that I handled where a truck collided with a motor vehicle, causing serious injuries to our client. At the time of the accident, our client was leaving a Dunkin' Donuts on her way to work. She made a left-hand turn onto the roadway, and her vehicle was struck in a collision with a dump truck. This was an extremely challenging case. One of the reasons that it was challenging was that our client had absolutely no memory of the accident because she suffered a traumatic brain injury. So we were left with trying to determine how the accident happened and who was at fault. This wasn't a situation where we could ask our client, how did the accident happen? And she could tell us exactly what occurred. So we had to rely on a lot of different evidence in order to establish who was at fault for the happening of the accident. During the course of the case, we obviously had information from the scene of the accident that was taken at the initial investigation, including the police report, rendition of how the accident happened according to the defendant, and some physical evidence from the scene, including photographs of the vehicles, photographs of the scene, photographs of damage to the vehicles, as well as evidence of skid marks in the roadway. We had to analyze this information and see if we could put together how the accident occurred. We took that information and then we were able to take the deposition of the defendant. And one of the things we realized when we took the deposition of the defendant was that he was not being truthful about how the accident occurred. In this case, the defendant testified that he was driving down the roadway, and when he was about a block and a half away from the Dunkin' Donuts, he saw our client pull out of the parking lot. He said that our client pulled out and attempted to make a left-hand turn onto the roadway. That's information that we already knew, and we knew that information from the police report and information from the scene that the police gathered. We also knew that our client was not supposed to make a left-hand turn onto the roadway, and that it was a violation of the vehicle and traffic law to do so. We then took that information and began to question the defendant as to the details about the accident, and his story just didn't make sense. It didn't jive with the evidence. The defendant testified that he was driving a mere 30 miles an hour when he first observed our client's vehicle come out of the parking lot. And he said that he was a block and a half away at that time. He testified at his deposition that he immediately began to apply the brakes, first in a medium fashion, and then began to press his brakes in a heavy fashion. At that point, while he was in the right-hand lane, he began to move the truck into the left-hand lane. And ultimately, he collided with our client's vehicle. This just could not have happened. It couldn't have happened because common sense tells you if you're a block and a half away, only doing 30 miles an hour, and begin to immediately apply your brakes, the accident would not have occurred. So what we did was we retained an expert in the field of accident reconstruction. And we asked that expert to analyze all the evidence in the case, including the testimony of the defendant driver, the physical evidence from the scene, the skid marks, and the property damage. And when the expert took all of that information and he performed scientific calculations, he was able to determine that the rendition that was offered by the defendant at the time of his deposition was absolutely impossible. And what we learned from working in close consultation with our expert accident reconstructionist was that it was clear that the defendant was traveling well in excess of 50 miles an hour, well in excess of the posted speed limit of 25 miles an hour. We learned that the defendant could not have applied his brakes when he said he did so, and we learned that if the defendant had not moved from the right-hand lane to the left-hand lane in the direction that our client's vehicle was traveling, the impact would not have occurred. We learned that the defendant left 108 feet of skid marks in the roadway. And by analyzing the property damage, the skid marks, our expert was able to determine that the defendant was traveling more than twice the legal speed limit. And by consulting with experts, by gathering information, by making sure that that information and evidence is analyzed by someone who's qualified to do so, we were able to establish that the defendant bore the majority of responsibility for the happening of the accident in this case. And with that, we were able to secure a settlement for our client. We were able to secure a settlement of $1,800,000 for this young woman who was tragically injured. People who are accident victims often find themselves in situations where they don't think that they can prove someone else is at fault. They think, I don't know if there's someone that's able to fight for me to get the justice I deserve. If you are involved in an accident, it is vital to hire lawyers that have the skills and the expertise and the knowledge to investigate that accident, to truly uncover who, if anyone, is responsible. The lawyers here at Block, O'Toole & Murphy have the experience, the training, and the knowledge, and the compassion to make sure that the truth is uncovered.